Welcome to episode 6 of Back to Basics, Employment Law. I'm Michael Geib, an employment lawyer at Parley McLaws. In today's video, I'd like to discuss frustration of contract as it applies to employment relationships. A contract of employment may be frustrated if the circumstances under which the contract was made change so fundamentally that its performance is either impossible or radically different from what the parties originally intended. For frustration to exist, neither party can be directly at fault for the situation in question, and the events must have been unforeseeable when the parties entered into the contract. An employment agreement deemed to be frustrated is automatically terminated. An employee cannot seek compensation for wrongful dismissal and may lose entitlement to benefits such as a minimum notice period. As the consequences of frustration are considerable for the employee, the circumstances under which the courts find frustration are limited, and the evidentiary burden for employers is substantial. An employment contract may be frustrated in instances of illness or disability, death of the employee, and in limited cases of the employer, loss of professional qualifications, a change of law or supervening illegality, incarceration, relocation of the employee, or natural disaster. In many cases, if a contract provides long-term disability benefits, the employer is prevented from claiming frustration due to illness. Human rights legislation also generally obliges employers to prove that they have endeavored to reasonably accommodate an ill or disabled employee prior to alleging frustration of contract. Should an employee die, the employment contract is deemed frustrated, as the agreement implies personal performance of job-related duties. Likewise, a fire or other natural disaster that destroys a workplace may make employment impossible or unnecessary. Frustration may also occur if the employee loses a professional qualification essential to his or her role. Nonetheless, situations that disrupt employment do not automatically amount to frustration. In all but exceptional circumstances, strikes and labor actions do not frustrate an employment contract. Courts have deemed labor unrest foreseeable and within the contemplation of the parties at the time of contract execution. Therefore, strikes and work stoppages do not generally qualify as frustrating incidents. Similarly, poor economic conditions are considered a foreseeable risk of doing business. Whether you're advancing or responding to a claim of frustration of employment contract, ensure you speak to an experienced employment lawyer before taking any action that may prove harmful to your legal position. Thank you.